In this case, Your Honor, the court, there are several errors as a matter of law that the court had. The first one is just the standard that the court used in a motion for summary judgment. If you look at the first page, the second paragraph of his order, nowhere in his order does he try to determine that there's no genuine issue of material fact and that the moving party is entitled to a judgment as a matter of law. The only thing the court says with regard to any standard that the court applied was to prevail on summary judgment, Mr. Kington must prove that Ms. Christmas does not have sufficient proof to establish the essential elements of her claims. It's clear that the court weighed the evidence as opposed to applying the summary judgment standard. The defendant, who is a psychiatrist, was dating my client, and every time they broke up, he filed something and did something. The first time they broke up, he files a civil case with a restraining order requiring her to return jewelry that he claims she took from him and that he owned. She files an answer saying, no, you gave these things to me as a gift, and a notice to take the defendant's deposition is given, and the defendant takes a non-suit. They not only begin dating again, but they end up getting engaged. And when they break up the second time, he files another civil suit against her with a restraining order attempting to get this jewelry back. The second suit adds a few additional pieces of jewelry but repeats the ones that he had in the first case. And she again says, no, these were gifts that were given to me. You don't own these, I do. A notice to take his deposition is given, and he again files a non-suit. And again, the second case was filed more than a year after the first non-suit. He admitted, and we've got in our undisputed statements of fact, that he knew by taking the second non-suit that he could not legally claim ownership in the jewelry because that was the essential question in the two civil cases that he filed, and that was really, in essence, the only issue in the civil cases is who owned the jewelry. Well, since he knew he couldn't file a civil suit against her, another one, he contacts the police. Now, he's well familiar with the criminal justice system. His father was the longtime chief of police of the city of Chattanooga, and according to the statements of undisputed fact, at least some of the pieces of jewelry that he claimed were stolen, he knew he had given to her as gifts.
Let me ask you about that, counsel. You said that in your brief that at least some of the items were gifts. Does that mean some of them weren't gifts?
No. All of them were owned by her and were gifts, but he admitted that at least some of them were gifts.
So she claimed they all were gifts.
She claims they all were gifts.
And he says they weren't gifts.
Correct.
Okay.
And according to the undisputed statements of fact, he knew that she didn't steal them. He knew that the information he gave to the police was false. Due to these false allegations, she's indicted for theft. And once the district attorney investigates the proof in the case, the district attorney voluntarily dismisses all charges against her. We've got, as part of the undisputed statements of fact, that he knew the information he was giving the police were false. He knew that the statement, the verified complaint that he gave was not true.
You're saying those things are admitted by him?
No, they're not admitted by him, but They are allegations of undisputed fact submitted by the plaintiff,
Okay.
which in a motion for summary judgment, we're trying to see if there are genuine issues of fact.
I understand that. I misunderstood. I thought you said it was admitted that he knew that his statements were false.
Well, he didn't admit it, but he admitted that some of the things that he gave were gifts. But anyway, we're trying to see if there's a dispute among the facts. Also, in our undisputed statements of fact, we show that he had also accused other women that he had dated of taking jewelry that he had given them as gifts. The trial court, in addition to applying the improper standard on a motion for summary judgment, applied the old law with respect to probable cause and also applied it incorrectly. The court made the decision on probable cause, and in the Roberts versus Federal Express Corp case that we cited, the court went through the history of these cases and said the existence of probable cause has long been characterized as a mixed question of law and fact. And they go through a discussion and overrule all of the prior cases to say that the court is to make the determination of probable cause, and say that because we now hold that where reasonable minds can differ as to the existence of probable cause, a jury is to decide the issues, the judgments of the lower court must be reversed. The court did not apply this law, and as a matter of fact, the court went against the law by letting the court, or the court did make a finding on probable cause, which when there's a genuine issue of material fact, the jury is supposed to decide it. The Poster case that we have cited says that you should look at the events and that malice can be inferred if the criminal case is to enforce a payment of a debt or a return of property. In this case, it was to try to enforce the return of jewelry. The Poster case also mentioned that the abuse of process cases are similar to malicious prosecution cases in that the abuse of process works on the fears of the defendant under arrest for the purpose of extorting money or property, in this case, property, and who better to know how to extort fears than a psychiatrist that knew this woman intimately. The Poster court also said that a mind beclouded by prejudice, passion, hate, and malice is not such a reasonable mind as the rule contemplates. So I think this is the textbook situation of that definition in Poster, because every time she broke up with him and in fact then canceled their engagement, he files either a civil case or criminal charges against her.
Let me ask you, you say he filed criminal charges. How did he go about filing criminal charges?
Well, he contacted the police department and he gave false information to the police department. He also withheld information from the police department, never told them about the prior civil cases, never told them that he had given her anything as gifts. Yes, technically she was indicted, but she was indicted because of the false information that he gave to the police, and she was indicted because of the withholding of information.
Before that indictment, didn't the police department conduct an investigation first?
They conducted an investigation, but the indictment was founded upon the information that he gave. Once the district attorney looked at the information and investigated himself, then the district attorney dismissed all charges.
In regard to this abusive process, what process did the appellee file in this case? What process are you referring to? There's got to be a process.
Well, what happened is the appellee contacted the police department, gave them information. They acted upon the information. They did some investigation, but based upon what he said. And I might say that one of the things he told them is that my client's son had called him and told him that she's the one that took the jewelry. Well, there's no way we can disprove that. The son is dead, died after this alleged conversation. But anyway, what we're trying to show is that there is a material dispute in the facts, and therefore a summary judgment would not apply, number one. Number two, the court is the one that found probable cause, and according to the case law, once there's a dispute of the facts, then the jury is supposed to decide it. We've cited cases.
Well, the trial court found there was no dispute. I mean, the trial court said it's clear there was probable cause for the arrest.
Well,
are you arguing that there was not probable cause for the arrest? I mean, I assume that's what you're
arguing. Two things, Your Honor. One is that there was not probable cause because the defendant is the one that gave the information that caused her to be arrested.
Including information that he told the police that he knew there had been two people in his house and he didn't know who had taken the jewelry.
Well,
I mean, is that what he told the police?
That's the first thing he told the police, but then he tells the police that she's the one that took it, that her son called me and said she took it.
Okay.
And this man is intimately familiar with police procedures. His father was chief of police, but we're kind of getting away from the issue. The issue
I think that is the issue here on malicious prosecution, was the trial court found there was probable cause. We're not looking at whether or not summary judgment was appropriate as to who owned this jewelry. That's not really the issue before us on appeal.
Your Honor, what I believe the issue is number one, if there is a dispute in the facts, who is supposed to decide it? And under the Roberts case that we've cited,
if there's a genuine dispute of material facts.
And we think there is.
That's the rule on any summary judgment motion, isn't it?
Yes, sir. Okay. And the reason we're saying that is that we've put into our undisputed statements of fact a lot of issues that the court did not consider. The court also did not state that the standard that he is deciding this case on is whether there is any genuine dispute of material facts. He just weighed the evidence. And weighing the evidence, he said, I find that there is probable cause. Okay. So
you have your time for rebuttal.
Thank you, Your Honor.
Thank you, counsel. We'll hear from the appellee.
Good morning. My name is Brian Haas. I'm here on behalf of Dr. John Kington, the appellee in this case. First, after the plaintiff, Ms. Christmas, filed the initial complaint, we filed a motion to dismiss. The plaintiff was allowed to file an amended complaint, which we agreed to. They filed an amended complaint. We also filed a motion to dismiss the amended complaint. The court entered a memorandum and opinion in order and dismissed many of Ms. Christmas's claims except two. And in that, the court wrote, it is ordered that the motion to dismiss be denied as to the malicious prosecution and abuse of process claims relating to the criminal charges brought against the plaintiff, Elizabeth Christmas. So the allegations that this process was issued against her based upon the civil lawsuits was dismissed by the trial court at the motion to dismiss phase. That's not before this court. They've not raised that, and in their brief, they've not raised that there was any error related to that ruling. All that's left for this court is our motion for summary judgment on those two claims for malicious prosecution and abuse of process as it relates to the criminal charges only. As factually, Your Honor, they were together, they broke up, they were together, they broke up, back and forth relationship. But essentially in July, Mr. Kington noticed, or in March, he noticed some pieces of jewelry were missing from his house. And on July 12th, he received a phone call from the son. And while the contents of that phone call are disputed,
Received a phone call from who?
from Miss Christmas's son,
Her son.
saying the stolen property is at this pawn shop in Nashville. And so the dispute, they dispute the contents of that phone call, but what they can't dispute is that Dr. Kington traveled to the pawn shop and located one of his stolen watches. He reports that to the detective down in Hamilton County, and the detective goes to Nashville and begins conducting his own investigation into this stolen property. He actually finds this male Rolex watch that Miss Kington pawned to the pawn shop up there, sent pictures back to Mr. Kington, who identified the stolen property, and then the detective proceeded with his investigation. This is not a case in which it's a he said, she said. There was a Hamilton County detective assigned to this case who investigated it. He took recorded statements from Dr. Kington. He took 2 recorded statements from Miss Christmas, one over the phone, one in person. He traveled to Shelbyville, where she owns a jewelry store, and interviewed her at that jewelry store with another Hamilton County deputy. He located property. He had Dr. Kington ID it, and he then the detective consulted with an assistant district attorney who concurred with him bringing charges against Miss Christmas. It was the detective who filed the charges of theft over $60,000 in Hamilton County General Sessions Court. Miss Christmas had the right to attend. She hired an attorney. She did attend. She had the right to have a preliminary hearing. She waived her right to have a preliminary hearing. If she wanted to question Dr. Kington, she could have done so at that preliminary hearing, but she waived that right, and the case was bound over. I will note the Hamilton County grand jury actually indicted her for a more serious offense. The detective charged her with theft over $60,000. The Hamilton County grand jury indicted her for theft over $250,000, which was an A felony. The case proceeded up to criminal court, and eventually an assistant DA dismissed the charge. The only evidence in the record as to the dismissal of that charge was that it was by agreement of the parties. There was no promise by the state that they couldn't come back and refile it at a later date, but it was eventually dismissed. The issue on malicious prosecution is whether or not there is sufficient evidence in the record to show that there's probable cause that a crime was committed. We don't have to show that she actually committed a theft. All we have to show is that there's a reasonable basis for the detective to conclude that she committed the theft. And in this case, there's ample evidence of that. We submitted it in the Statement of Undisputed Material Fact. Many of those facts were not challenged or not denied by Miss Christmas. I will point out there's one case I do want to talk about. It is Gordon versus Tractor Supply Company. It's a 2016 case, and it's discussing a grand jury's indictment, whether that creates probable cause just because of the fact of the indictment. And what the Court of Appeals found was that once there is an indictment, then the burden shifts to the non-movement to produce evidence that the indictment was somehow procured by fraud, that there was some fraudulent action that occurred in the grand jury. And there's no evidence in this record that there was any fraud committed in the grand jury stage, and Judge Hollingsworth found that in his order. Dr. Kington did not testify at the grand jury. He didn't provide documents to the grand jury. He didn't provide, when the case was in Sessions Court before the grand jury, he didn't testify there either because she waived her right to a preliminary hearing. He didn't provide documents to the prosecutor down there. The only thing he provided was a list of the items that he claimed were stolen from his house. I will say the initial...
Did the
Yes,
police, did the police officer testify for the grand jury?
So, well, I don't think we actually know that. I think we can guess that. I think we can assume that because Detective Sledge's name is on the indictment. And so in Hamilton County, when they indict someone, they'll put the individual who testified as one of the state's witnesses, and Detective Charles Sledge's name is on the indictment. So I think you can assume that he did testify, yes, Your Honor.
Okay.
The initial responding officer to Dr. Kington's house wrote in the report that it was either the housekeeper or the girlfriend, that he was unable to say who actually is the one who stole these items of jewelry. Regardless, once the burden shifts to them to prove that there was somehow fraud in the grand jury process, that they were unable to do so, and that's what makes summary judgment appropriate at this stage. The abuse of process count, the burden is on the plaintiffs to prove some act by Dr. Kington after criminal charges have been filed, that he did something that somehow abused the process, and they were unable to do that. Judge Hollingsworth found specifically that all that Dr. Kington did was show up when he was required to do so to the criminal matters, that he never testified, he never provided any documents other than that original handwritten list of items, and he didn't do anything to pervert the criminal process at that stage. And so respectfully, once the burden shifts to them to prove that and they're unable to show that, then Dr. Kington is entitled to a summary judgment as a matter of law. Thank you.
All right, thank you, counsel. Here from the appellant, rebuttal.
It's not just probable cause that the courts of Tennessee have said that the jury has to decide when there is a dispute in the facts. The Perry case, Perry versus Sharber, says that the jury is to determine whether the defendant disclosed all ascertainable facts. Well, he didn't disclose that they were gifts, at least some of them. He didn't disclose that he had filed 2 prior civil suits. He didn't disclose that even he knew that he could not claim ownership of these items in a civil suit. He didn't disclose that he filed all of these after breakups. So that also has to be decided by the jury. The Sharber case also talks about that when there is malice, and that malice is different. We've cited cases showing that malice is different in a malicious prosecution case than in a defamation case. And also we've cited the Lawson versus Wilkinson case, which supports our theory that there is lack of probable cause when the district attorney, after investigating the case, dismisses the case after learning all the facts. So the Lawson case is directly on point here. The jury, the Mullis v. Wells case says the jury should decide whether there's been a full and fair disclosure, whether he's made a complete disclosure of all the facts. And again, once all the facts were known, the district attorney dismissed the case. In the little bit of time I have left, I would like to talk briefly about abuse of process. We have cited cases in our brief that talk about the elements of abuse of process, and I don't have time to go into it all, but we've cited facts and the law in our brief. That abuse of process is if there's an improper motive, and that abuse process is intended to prevent parties from using litigation to pursue objectives other than those claimed in the suit. Well, the objective of a criminal case is to punish a defendant. His objective was to get jewelry back that he could not get by a civil suit. The abuse of process cases also say when the primary purpose is for spite and ulterior motive. This is a man that files suits or criminal charges every time that there is a breakup or a break of engagement. I am out of time. I be happy to answer any questions.
I hear none. Excuse me, I hear none. Court's thanks to counsel. We appreciate your oral argument this morning and your briefs. Call the next case, please.